Welcome everyone to this session with Professor Teresa Scassa. I am super excited. Professor Scassa's work, on a personal note, I can say has been really guided my thinking about AI and the law in Canada, and the book that she and her colleagues put out this year has been a real touchstone for kind of just framing what's happening in Canada specifically, instead of having to look at our colleagues to the US and Europe and other places, which is lovely. But it is nice to have some homegrown scholarship to reference. So not only this year, but in the past as well. So thank you so much, Professor Scassa, for joining us. I'm here again only to help along with questions and the like. So I'll hand it over to Teresa right away to share some of her thoughts on AI and regulation, and we'll jump in. So save your questions, and we'll come back to them for some discussion, because we have a nice amount of time for this chat. So without further ado, over to you, Teresa.
Well, thank you very much, Hero, for that lovely introduction, and also for the invitation to speak at the Digital Law Forum this year. It's great to be here virtually. I guess everybody's getting used to being in different places while still sitting at home in front of their computer. So I'm just going to take a second to pull up my slides for you. Yeah, so I chose the ever so small topic of the challenges of regulating AI for my presentation. And Hero has mentioned the book that that was published earlier. Well, I guess it was published about a year ago on AI and the law in Canada with LexisNexis, and it was a collection of papers by some of Canada's leading thinkers about AI and the law. One of the challenges of the book with each chapter was that there wasn't a lot of new AI-specific law. In many cases, the exercise was one of thinking about how existing laws might apply to AI and what some of the gaps are in that regime. And so my talk today is really exploring why we aren't further along in regulating AI, and what are some of the challenges that we need to address to get there. So just to set the context a little bit, because I do think this is very relevant to the challenges we're experiencing, AI has been identified as a key factor in economic growth, not just in Canada, but around the world. So AI is seen as being just, a fundamental driver of economies presently and in the future. There's also significant global competition for leadership in AI innovation. Canada sees itself as being in that mix. I think China, the US, and the EU are the real global leaders in AI innovation, but Canada does see itself as a tough little competitor in that context as well. Just another thing to note is that in the last 2 years of this miserable COVID-19 pandemic, we've also seen the adoption of AI skyrocket by one description, with AI being adopted in all kinds of contexts, including, for those of you who are in the university context, including in some cases the adoption, for example, of remote AI-enabled exam proctoring. I mean, there's just been a widespread adoption of these tools, in some cases perhaps partly driven by the pandemic, in other cases just as a matter of the steady increase in adoption of AI. It also continues to increase. McKinsey reports that the greatest rate of growth presently is in companies with head offices in emerging economies. Now, they include China as an emerging economy, and certainly there's a tremendous amount of growth there. But this is a global phenomenon. And while considerable work has been done to set guidelines for ethical and responsible AI development, uptake has been very uneven, and I'll talk a little bit more about that in terms of the challenges. The other thing, of course, is that there are now such an abundance of potential applications for the use of AI across both public and private sectors. So that's a little bit of the AI context. So the first challenge that I would identify is that AI innovation is outpacing law and regulation, and that seems like a pretty obvious thing to say. I mean, you know, in a sense, one of the reasons for having this topic at the conference is just that we are struggling to keep up with some of the challenges posed by um, regulating AI. And the challenges are varied and different. In some cases, we have laws or regulatory systems that are simply not fit for purpose. Our data protection laws in Canada, now with the exception of Quebec, which has just passed a new modernized data protection law for its public and private sectors. In Canada, data protection laws require modernization. They were not drafted with the big data AI economy in mind, and they are not they're simply not well adapted to that context. We hear a lot about algorithmic discrimination, but our human rights legislation is not well adapted to addressing algorithmic discrimination. We have medical device regulation, which is a poor fit with AI. There are some types of AI that may be brought under existing medical device regulation frameworks, but it's overall a poor fit. And so we need to be thinking as AI develops for use in healthcare, for example, we need to be thinking about what we need to have in place to properly regulate the use of AI in healthcare. So it's also the case that we have areas of law that are going to need to adapt to new challenges. So, for example, areas of common law like administrative law will have to adapt to the increased use of automated decision making by governments at all levels. And so we'll need to see the evolution of administrative law principles as we start to think about what constitutes a decision, what kinds of notice rights are required, what kind of, what do reasons look like? If you have a right to reasons, what do reasons look like in the context of automated decision making, and so on. Tort liability, as the common law starts to evolve and starts to take into account the use of algorithms in a wide range of contexts, how do we adapt and develop the principles of tort law? And those can continue to evolve through the common law, but of course, there can also be legislative intervention. We may need purpose-specific legislation or regulation. In some contexts, I've given the example of automated vehicles, where it may be that you simply need to create a new regime to address or deal with some of the issues that are posed by a particular technology that is in widespread use. And of course, existing rules and procedures may need to be adapted. And I've given here the example of rules of civil procedure. There are going to be some very interesting issues around facts, procedures, evidence related to AI that will have to be addressed. So, this is a huge problem, right? It's not simply stepping in and saying, okay, we need an AI regulation, or we need to regulate AI. The challenge to the legal system is very broad. Another challenge to AI regulation is that we're in the middle of a global race which is not conducive to go slow approaches. I've mentioned before that this is very competitive, and companies are jockeying for leadership in innovating in AI, and that Canada sees itself as being a player in this context. I've put in a couple of headlines here on the screen that show Canada's aspirations in this context. And there's a huge amount at stake economically in terms of being a leading innovator in AI. And so in that context, governments are obviously going to be reluctant to introduce laws or regulations that stifle innovation. We've seen this with data protection as we sort of evolved into the into a data society. It's a common refrain with data protection laws to say we don't want to pass too stringent protections because that will stifle innovation. We have to be very careful how we protect privacy, but you don't want to stifle innovation. And we're facing something very similar in the context of AI. How do we regulate without stifling innovation, with innovation being seen as something that is in the best interests of Canadians in this context. Another challenge of regulating AI is the sheer diversity of AI applications. AI is affecting every sector, every area of the economy. It's impacting science and engineering and technology. It's impacting the world of finance. We have already seen some of the effects of AI in the social media context. Precision agriculture is an area that is gaining a great deal of attention. Talked a bit about automated vehicles. The list just goes on. And so we're seeing the effects and impacts of AI applications right across all sectors and all areas of activity. And so in the private sector, you know, there's the applications are simply too numerous to mention. In our everyday lives now, we encounter AI, whether it's chatbots or whether it's exam surveillance or workplace surveillance, drone deliveries, automated vehicles, biometric technologies that may just be on our smartphones, you know, an iris scan to get into to your smartphone, or it may be more substantial than that. Companies are now using AI in hiring. So the applications for AI are enormous and ubiquitous. In the public sector, we're seeing governments exploring the use of automated decision making, using chatbots for service delivery. They call them service bots, I think. Translation services. This is a big one in a country like Canada with 2 official languages. To start to use AI for translation is quite a big thing. Natural language processing for analyzing and extracting information from massive quantities of text or data. Hiring, monitoring, evaluation of public sector workforces. The use of AI in healthcare is really expanding and looked to with great interest. And we've also seen lots of news coverage of issues around predictive policing, facial recognition technologies, the use of AI for national security and border security, and so on. And so there's, again, just a proliferation of the use of AI in the public sector as well. In terms of this, again, the challenge of the diversity of AI applications, I think there's also a pretty broad spectrum of types of AI applications that are being developed. And so some AI developers are looking to produce socially beneficial AI. And in fact, many people who are quite passionate about AI and who work in the field are passionate about the potential that AI could have to solve problems, to do things better than humans. So in the healthcare context, for example, you hear lots of talk about improving diagnostics, improving workflows within hospitals so that patients get so that healthcare resources are distributed or used more efficiently. People get better access to healthcare. Better access to justice through the use of AI, again, either in streamlining workflows or in providing service bots that may assist people with some of their issues that are less complex. The use of AI to discover new medications. You hear, for example, people talking about the looming crisis of the failure of our known antibiotics and the development of antibiotic-resistant infections, how AI might be the solution to that problem because it will allow for a pace of discovery that far exceeds what humans are capable of. AI as a potential solution to climate change problems. We're even seeing, although we hear a lot about biased AI and discrimination in AI, there are some who say, well, AI can actually, humans are biased, and we know that too, and that AI could be used to try and reduce or eliminate some of the biases that people show in processes like hiring and so on. So you've got lots of people who will tout the benefits of AI and the fact that there's the development or a lot of energy going into developing AI that will solve problems and make life better. On the other end of the spectrum, we're also seeing right now in real time the use of highly exploitative AI. And so these can include technologies that profile and target people with an idea to manipulating their thinking, uh, whether it's political thinking or preferences, or to try and manipulate people into purchasing certain types of products and so on. We see AI for social scoring, essentially giving people, scoring people or ranking people, profiling people in a profound way that may impact their ability to gain access to services or other needs. Price discrimination, using AI again to profile people to determine what price they are most likely to find acceptable, or what they'd be willing to pay for certain products. And so you have those exploitative uses, and it's a spectrum, and there are other sorts of uses in between that are, more ordinary. They're perhaps not as beneficial, not as exploitative. They fall somewhere in between, but you get a sense of just the broad diversity of applications, which also has an impact when thinking about regulation. Another challenge, of course, is that in an environment of unregulated AI development, there can be, this can raise significant problems. And we are starting to see some of those problems. I've mentioned some of the exploitative uses of AI, and governments are struggling to come to terms with and find ways to address or respond to some of these clearly exploitative uses. And I just want to talk a minute about another example that's gotten a lot of press, and I think is a really interesting example, in part because it also draws on the fact that we were slow to regulate data protection, and there's a data protection element here as well. So many of you may be aware that there is this company, a US-based company called Clearview AI, which went out and scraped, so automatically harvested images from publicly accessible websites like social media pages, Facebook, Instagram, and so on. So scraped photographs of individuals from those websites, also from news sites, basically from a range of different publicly accessible sites on the internet, scraped those photographs, and then used those images to develop a powerful facial recognition database. Which it then proceeded to market to police services around the world. The activities of Clearview AI were made public by the New York Times in an article in January 2020. And since then, Clearview AI has had to deal with data protection complaints in countries around the world. And so most of the battle with respect to Clearview AI has been happening at the level of data protection complaints, but there also have been investigations of law enforcement services that have adopted Clearview AI. So some of the issues, and so this is an interesting AI example of an AI problem, because you've got at the very least two broad dimensions here. On the one hand, you've got the fact that police services adopted and started using Clearview AI's services in fairly non-transparent ways. So you have the whole issue of how the public sector adopts AI and begins to use it. And then on the other hand, you had the issue of the legality of the creation of the database in the first place. So on the use by police dimension, one of the issues that was there was obviously the lack of transparency, and that's lack of transparency in adoption and procurement, as well as in use. It was not clear. The New York Times broke its story. There were reports that there were police services in Canada that adopted it. I don't know if you recall the coverage at the time. There were a lot of police services that said, oh, no, we don't use Clearview AI, and that had to later come back and say, yeah, well, some of our members have used Clearview AI. We didn't know about it, but some of our members did, and others were forced to admit that they, as a service, had adopted Clearview AI. But this was not transparent to anyone, and procurement practices are really important. especially when it comes to things like these outside tools. How are they dealt with? How are they addressed? Is this a consulting service? How does it get recorded? How do people understand what has been procured? In the case of Clearview, the AI, they were giving free usage or to promote its use to individual officers who were using it without any direction from the chain of command. So lack of transparency is a huge issue. Lack of a governance framework was also a big issue. I mean, if a police service is going to adopt a technology like this, there needs to be some sort of framework. In what context is it okay to use it? For anything, or is it only for certain types of crimes? Who uses it? Anyone, or only officers of a certain rank or in a certain position? In what circumstances does it get used? What kind of prior approval is required? And then when you get to oversight and accountability, what kind of paper trail is required? What kind of audit or oversight is provided to ensure that it is being done appropriately? All of these issues are important ones, and none of those were in place. There's also the broader issue of who assessed this service for quality, fitness for purpose, for adverse impacts. We hear a lot about discrimination with facial recognition technologies. We also hear a lot about discrimination with respect to police services. Who looked into that? What kind of assessment was made of that? And then, of course, there's the fact that the database itself was illegal, and I've provided a link on the slide to an announcement by the Privacy Commissioner of Canada, who was investigating complaints against the RCMP, who noted that it simply would never be acceptable for the RCMP to use a database that was illegally compiled, and this one was illegally compiled according to the Privacy Commissioner because it breached data protection laws in its compilation. So that's just the public sector. Those are just the issues, the governance issues on the public sector side. If you look at the privacy issues, there were fundamental questions about the appropriateness or legality of the development of the facial recognition tool itself, of creating that database, issues around whether notice or consent of collection was provided, whether the collection would be considered reasonable under Canada's data protection laws in any event. And so the collection of that data, the legality of the collection of the data was called into question, not just in Canada. There have been actually decisions already rendered against Clearview AI in Canada at the federal level, in Quebec, Alberta, and BC, in the UK, in Australia, and in some jurisdictions in the EU. So the decisions are starting to roll in, finding that there were breaches of data protection laws in the collection of this data. Another challenge here, of course, though, is that we live in a global economy, and this is a company that was operating on a global scale. The most permissive data protection regime, that in the US, became the baseline to justify the practices of the company. And Clearview AI has maintained all along that this data, these images on social media websites, are in the public, and there is no privacy in public spaces. They're also arguing that they have a freedom of expression right to collect information from public venues. And so they're basically saying, these are our rules, these are the rules that we play by, and we really don't care what you think in these other countries of yours. So that leads to yet a further challenge, the lack of a clear global framework for data protection or privacy. And then on top of that, there's the lack of an obvious effective recourse. Now in Canada, I mentioned that there were decisions that Clearview AI had breached Canada's data protection laws. There has to be a real and substantial connection to Canada for those laws to apply. At a certain point in time, Canadian police services were using this. They have apparently now all stopped, raising the question of what's the real and substantial connection. I think you can still find one, but the problem is you have an American company that is no longer doing business in Canada that has the data of a very large number of Canadians in its facial recognition database, and it's just not clear what the recourse or the remedy is for those Canadians if they want their data removed from the database, right? So it just shows some of the complexity. and I just want to say this is an AI regulation complexity, it's a data protection regulation complexity, and it's also the kind of situation you get when you haven't dealt with these issues up front. When you allow businesses to evolve, to develop, to innovate, to create products, bring them to market, have success with them. In an environment where you haven't regulated, then it becomes very difficult after the fact to rein that in. And we're seeing that with Facebook and Facebook's use of data. I certainly remember back in the early days of data protection law when people were raising questions and issues about the whether the law was adequate to address some of these issues, and the response being you don't want to stimulate it, you don't want to stifle innovation. Innovation is a good thing. These companies are innovating. Well, they are. And some of the innovations are going to be great and valuable, and some of the innovations are going to cause problems. So this is a very serious challenge for AI. Another challenge, of course, is choosing the regulatory tools that are appropriate. And of course, with such a broad variety of innovators and applications and contexts, you may have to be choosing different things from the toolbox. Right now, there's a lot of emphasis on voluntary since we don't have a lot that's mandatory. And there is some research that shows that there are a number of companies, usually the larger, better resourced companies, that are putting a lot of thought and care into responsible development of AI, and are adopting these internal voluntary measures. But there are also many companies that are simply not doing that. They may not have the awareness, they may not have the resources, they may not have the inclination to do any of the voluntary oversight in the development and bringing up their products or services or applications to market. And we currently don't have a lot on the mandatory side to back up good governance. And so that's one of the challenges. But there are a range of different tools. In the middle column, I've put private ordering. Mostly those work around things like data if a company is getting its data from a data sharing framework. So for example, in the health context, the access to that data may be provided according to terms of a license that impose certain use requirements and limitations on that data. We know if it's university research, for example, or hospital research, ethics review may be a condition of funding or a condition of access to data. And so you can have organizations or companies bound by contract or private ordering through this kind of in this middle column. Otherwise, they have a range of tools that they can adopt on a voluntary basis. And then we have a series of different types of laws that can apply to greater or lesser extents and in some ways, but that are often not yet tuned to address or deal with AI specifically. So there's a range of tools in the toolbox, but they're not some of them are fairly blunt tools. Many approaches to AI governance or regulation use risk as a way to sort AI for purposes of regulation, and so it's one of the ways in which regulators try to come to terms with that broad diversity of applications that I talked about. How do you sift through that? How do you adapt whatever regulatory mechanism you're going to use to such a diversity of tools? And so risk or harm has become a way that many have used to approach this issue. And risk-based frameworks are interesting, but they do raise the question of how do you assess risk? What do you identify as risk, and how do you assess its severity? Because they do depend on sort of calculation of severity. To whom is the risk relevant? So, and I'll show you some examples where that comes up. And then once you've got your spectrum of risk, what obligations should map onto the different levels of risk? How do you determine which obligations will apply to which category of risk? So the Toronto Police Services has just completed a consultation on an AI policy. This was interesting. I've put the URL up here. It was an interesting process. obviously, police services in Canada had quite a bit of blowback from the adoption of Clearview AI, which I mentioned to you as an example. And it was clear that there was a lot of public anger, public frustration about facial recognition technologies, concerns about discrimination, concerns about the legality of the AI tools that were being made available to police and how they were adopting them. The Toronto Police Services decided to be proactive and to develop its own AI policy. Interesting also, because I think in part this was responding to a gap, a regulatory gap. So this is the Toronto Police Service, only one police service of many in Ontario developing a responsible AI policy, which could have perhaps come from the provincial government, right? But didn't. And so I think this is another interesting issue or challenge in regulation, like who's going to act and at what point are they going to act? So you have the Toronto Police Services acting in this AI consultation. The consultation proposed a risk-based framework with 5 risk-based categories. And so on one end, you have extreme risk, and they provide the example of a facial recognition software with illegally sourced data that could result in mass surveillance. Sounds like Clearview AI, right? But they didn't mention that, but that's on the extreme risk. And then they've got high-risk systems, medium risk, low risk, and minimal risk. And so the example they give of minimal risk is a translation engine that helps communications convert the service website into different languages. Okay, so there's your risk spectrum, and then depending on where the tool falls within that risk spectrum, you have different levels of obligations, oversight, accountability, and so on. And so that way you can focus your attention where it's most needed. And the suggestion in the consultation was that extreme risk applications should never be adopted, should not be adopted. They're just off the table. If they're identified as extreme risk, then they're not available for use. Another example, Canada at the federal level adopted a directive on automated decision making. And this is a really interesting directive. It's been adopted by the Treasury Board and is meant to apply to all automated decision making in the federal government according to the definition of automated decision making and according to a particular start date for the directive. And so it's an interesting model for thinking about how to procure, design, and implement automated decision-making in the government context. And again, the approach adopted in this directive is to create a sliding scale of obligations based on the degree of risk. And I think this one's interesting as well because they talk about the degree of risk to the rights of individuals or communities, recognizing that some decisions have a community level impact and not just an individual impact, to the health or well-being of individuals or communities, the economic interests of individuals, entities, or communities. So you see corporations coming in there. So if it's an impact on an economic interest, then the risk to that economic interest of corporations as well as individuals or communities is considered. And then the ongoing sustainability of an ecosystem. So putting the environment in there as well, risk of harm to the environment. And so that's an interesting framework, well adapted to the context of government decision making because it does cover that broad spectrum. But I think it's interesting to note the thought that was put into not just what kind or what level of risk, but risk to whom or to what should we be taking into account. And so that's another example. The EU AI regulation, which is a draft regulation, which is currently being debated in the EU with a view to eventually bringing it into force, also adopts a risk-based approach to AI regulation, with the strictest requirements reserved for those systems that pose a high risk to the health and safety or fundamental rights of natural persons. Okay, so again, thinking about who do you identify as, as the constituency, the group, and here it's natural persons. It also adopts an approach that creates an all-out ban on some types of AI that are considered exploitative, and gives some examples of types of AI that are just considered to be unacceptable, outside the pale. They are simply banned, and that's an interesting approach. It's a controversial approach, but it's an interesting one as well. You can imagine it controversial in a context that says, "Oh, you don't want to stifle innovation; let people do what they do, and then sort it out later." But this is an approach that says some things they're just not worth doing. Don't go there. Although they're all these exceptions are all qualified. So just some three examples of the approaches to risk-based frameworks for AI regulation. Another challenge or another issue is in thinking about the choice between ex ante and ex post regulation of AI. Ex ante is before the fact. So this is imposing requirements on developers of AI applications before those applications are released for public use or for adoption. And so ex ante measures can be voluntary. I showed you a table earlier with a whole bunch of voluntary measures on them, and many of those are ex ante measures. Or they can be imposed by regulation. They can relate to organizational practices or procedures. They may relate to data governance, and data governance is obviously important. And so again, that can range from obligations that are internal, but also ones that are imposed by law, like data protection laws. They can relate to ethics, including voluntary or mandatory ethical frameworks, ethical oversight or review. They can relate to algorithmic impact assessments, which can be voluntary or required by law. And I guess what I'm saying here is that you can have these ex ante measures that are voluntarily adopted. You can also have a regulator or a government decide that they will impose these measures on organizations, and they have to do some of these things before they bring AI to market, or perhaps they have to do some of those things depending on the risk assessment if you have a risk framework. Transparency requirements as well. What do you have to disclose? What do you have to tell about what you're doing? Regulatory approval systems as another ex ante measure. If you have to have your product or your tool assessed and approved before it can go to market, and that's often done with medical devices for product safety or hard limits. So those are some of the ex ante before the fact possibilities that are available to regulators to make sure that the AI that goes onto the market is safe and appropriate. And there's also ex post regulation after the fact, after the product or service gets onto market. And those can be requirements for ongoing review or assessment, which can be quite important. For example, it may be that a machine learning algorithm in the medical diagnostics field at the time it's approved is very effective and shows no discernible bias or no significant bias. But it may be that over time, as it continues to operate, if you start to look at the results, you're going to detect that there's bias in the results that it's producing. And so this ongoing review or assessment of algorithms, particularly where ones that involve machine learning, can be an important ex post form of governance. Post-market regulatory oversight is part of that. And then the other ex post measures relate to individual recourse. So individuals can bring complaints under privacy legislation, under human rights legislation, if they're adversely affected by public sector automated decision-making. They could use judicial review proceedings to challenge the decision that's been made. Litigation is possible if they're harmed by a product or service. They can sue in tort. If their rights have been violated, they can sue under the Charter of Rights and Freedoms. And so, these are all mechanisms that are available and in place. They may, again, not be sufficiently fine-tuned or adapted yet to AI, but they are there. But individual recourse, I think, is one of those things where we need to be careful. The conditions for success will depend upon sufficient transparency, which may have to be addressed through law or legal change, right? If you can't tell how the decision was made, and it's a trade secret and you are not given access to it, how do you begin to challenge? What if the data is also a trade secret? How do you begin to challenge an algorithm or its operation if you can't get access to it? Notice, how do you begin to challenge something if you had no idea that it was being driven by AI? Resources are tremendously important. Those are human, technological, and financial resources. If you don't, it can be very, very expensive and time-consuming to sue, especially when you're suing in a context in which the law hasn't fully evolved. It's unpredictable. You don't know which way judges or courts are going to go. You don't know what the outcome is likely to be. It increases uncertainty. It can certainly increase cost. The legal tools, for example, may not yet be sufficiently developed. I just put a reference to Ewart in Canada there. It's not an AI case, but I do think it is a case relevant to AI, and it involved a Métis man who brought a challenge to standardized tests that were used to make determinations about incarcerated individuals, and his argument was that they were biased or discriminatory, and they did not take into account, or that biased or discriminatory with respect uh, to him as a Métis man, and he eventually won. But I think it was, a victory that should give everyone pause, because it took a very, very long time and a tremendous amount of resources to get to that point in the first place. And secondly, he lost on the charter issues. He won on statutory issues based on an interpretation of the law by the judges, but he lost on charter issues because of failure to meet the burden of proof for discrimination. And I think that in and of itself raises some really interesting and important issues for addressing AI algorithms. And so I'm just going to quickly summarize some of the other challenges that we're that I think are relevant in this area. Harmonization is one of them, both international and domestic. So I mentioned before, this is a global context, and there are going to need to be some kind of harmonization in both data regulation approaches if you're not going to end up with Clearview AI type situations where you have offshore actors playing by completely different rules, having this adverse impact. So international harmonization, I think, is something that we need to be thinking about. Domestic harmonization is also important. We have the potential in Canada to end up with different rules and different principles for AI and AI innovation across the provinces and territories and at the federal level. And I think that this is an area where we need to be really attentive. We're already, seeing the potential for fragmentation around data protection. Businesses don't like it because it is much more cumbersome and burdensome to comply with different regulatory requirements or process requirements in different jurisdictions within the same country. They see it as imposing an unnecessary and unacceptable burden, but it is also confusing. It's unnecessarily duplicative and problematic for those reasons as well. And so Canada needs to do better on domestic harmonization. Capacity is going to be huge, and you'll probably hear over the course of today and tomorrow many issues related to capacity of the public to understand their rights in the face of AI, capacity of lawyers to deal with litigation and legal issues that arise involving the use of AI technologies, capacity within government, not just to develop regulations or oversee AI, but also to implement fair and appropriate AI solutions within government, regulators, decision makers. There's a tremendous amount of capacity to build, and resources are also required. And then a final, and I can't emphasize resources enough. I mean, some of this is going to be very expensive, and if the Competition Bureau and the privacy commissioners' offices and human rights commissions are not properly resourced and funded, then they will have a great deal of difficulty dealing with some of the issues and challenges that are going to be raised by these technologies. And then transparency becomes important as well, and the laws and principles that we have in place to ensure an appropriate level of transparency and finding that balance between trade secrets and confidential information and the transparency needed to hold organizations to account. So I am going to just flag before I stop talking the beginnings of a way forward for Canada. What I've put in red at the top here, I've put in red because I consider them low-hanging fruit. Doesn't mean they're easy, but there's a lot of work that's already been done to modernize data protection laws, both in the public and private sector. We really just need to get on with it. And so I flagged that as low-hanging fruit. There's just no excuse for not having the laws that we need in place to deal with some of the data protection issues related to big data and artificial intelligence. Creating ethical and appropriate frameworks for public sector adoption and use of AI have also identified as low-hanging fruit. The federal government did a tremendous amount of work with its directive on automated decision-making. The Ontario government is doing some work in this area as well. You know, once you have the groundwork done, the prototype in place, there's no need to reinvent the wheel. This should be relatively low-hanging fruit for most governments, and is something where there simply needs to be action. Ensuring that oversight agencies have appropriate legislation and capacity to address AI issues is also important. Ensuring appropriate regulatory frameworks for higher risk AI, including post-market regulation and oversight, is important. And addressing accountability issues and ensuring that the burden of ensuring accountability does not disproportionately fall on affected individuals or entities is crucial. And I see this as, you know, this is one of my big concerns in this context, and I guess I'm going to end there in mentioning it, is that we do have systems that allow people who are harmed to attempt to be compensated for that harm or seek justice after that harm occurs. Not only is it less than ideal to approach AI or issues with the AI after people have been harmed, it's also inappropriate to put the burden of these new technologies, these new and challenging technologies, entirely on the shoulders of ordinary people who then have to find the resources to fight for justice after the fact. And so we really do need governments to step up and provide appropriate and accountable AI regulation. So I'm going to stop there. Thank you very much.
Thank you so much, Teresa. I have a page of questions. There's so much to dig into there. Thank you for such a rich talk. So I do have a few questions to sort of start us off with, and I'll encourage, if other people have questions, please come on up to one of the fabulous carpets with trees, if that works. And if not, you can use the chat to chat at me, and we'll make sure that your question, if you prefer writing it, that's totally okay, and I can ask on your behalf if that's what you prefer. So chat at me or come on up, as it were. So I'll just leave that, and please think about questions you might want to bring forward too. But maybe just to get us started, so this sort of goes back to the start of your talk, and it's something that I really appreciated in your book as well, that you started with this preface that sort of said, you know, and I'm paraphrasing inelegantly, but that let's not get hung up in what AI is and what AI isn't. It, as you sort of noted in your talk, it's ubiquitous, it involves big data, it involves sort of algorithms making decisions and providing services in a way that wasn't possible before. So let's take a look at that kind of in a practical way. Do you have any other sort of comment you would want to give on how you think about AI from a social legal perspective? Like, what are the useful ways of bounding it, or do we not bound it, and sort of, as you said, kind of focus more on it's big data being used by algorithms to change our lives?
Yeah. Yeah, that was really that was a very challenging part. I've been involved in a couple of things now where right at the outset we've sort of sat down and had that discussion about how do we define AI. And with the book, that was a big question that we had as editors of the book, and that our authors raised with us, which is, well, okay, so you've asked me to write about AI and this part of the legal system. How do you define AI? And we didn't want to be too prescriptive about the definition of AI, in part because it's a changing and evolving technology. And so there is a risk that you create a definition that is too technologically specific, and that turns out to be limiting going forward. But we did also want to focus on some of uh, the broader constituent parts from a legal perspective, and so which might be um, less important from a technological perspective, but from a legal perspective, for example, the fact that you are automating decision making, that you've got a tool to automate decision making. It's the automation of the decision making process that is legally significant. Now, how it's done and the inner workings of that technology may be important or relevant to legal solutions, but it's it's the specific impact that we wanted to focus on. So we tried to have a fairly open-ended definition for those couple of reasons, and this also came up on another project I was involved in, and again, similarly, we tried to have a definition that did not unduly constrain us because the focus was on legal, ethical, and social issues. So it's a bit of a cop-out, right? It's the kind of thing that technologists like to argue about a great deal, about what is and what isn't AI, and we were kind of like, we don't really, we don't think that detail is as important as the legal focus, but that's what we chose.
Yeah, thank you. It's helpful. You could, I would say, rather than a cop out, a functional definition, that it focuses on the impacts. But I do appreciate that. And actually, in one of the conversations that I had with some folks earlier this fall through an ethics forum at the University of Alberta, we actually came in part to this conclusion that in some ways the black box that people put around AI, and I'll thank Jeffrey Rockwell for his insights there, is more important than what's in it. It's as you sort of noted later in your talk, some of that, like, well, if we can't look at it, it doesn't matter what code you put in there or what decisions are being made because you made it a trade secret and you called it AI. So that's the important part in terms of looking at the social legal implications. So I just wanted to tease that out a little bit. So thank you for your comment on that. And I'll hand it over to Donna, who I think has a question.
Is my microphone working?
Yes.
Yeah,
oh, good, because my camera's not. Okay. Delightful talk and really helpful. So my concern is, with companies, for instance, and their blitz scaling and doing that sort of thing, where I was reviewing some of their process, and it's to just really not care about regulation and the law, and sort of apologize after the fact is a lot of what you see happening. So we are so behind the eight ball. Where do you see the leadership in terms of Canada? Because we're talking about provincially and federally, and how that alone is a pain in the butt. Like where is the leadership there in terms of legislation?
Yeah, that's a really good question. That's a really good question, and because that is, I think, the big concern, and it's certainly what we saw. We saw it with data-based industries. I mentioned this before. With Facebook, it was very evident at the time that people were saying, "Hey, there are going to be problems," and the response was, "Don't stifle innovation." So, part of it is this industry pressure on government not to impose significant regulation in a rapidly growing area, and so you constantly hear this refrain: "You're going to stifle innovation. You're going to stifle innovation," and governments may be afraid to act. So that's one piece of it, and I think that, and I'll deal with that piece first. And I think that something that has become that I've seen that I think is quite interesting in this same context is the extent to which public sentiment and public mobilization can really drive government in these contexts. We aren't seeing it so much around AI, although Clearview AI certainly helped. If you want to take anything positive out of that experience, Clearview AI and the uproar that it caused has certainly helped. But you know, some of the class action lawsuits, the scandals, Cambridge Analytica and other privacy scandals, the big data breach scandals, all of those have to some extent pushed government to accept that more needs to be done about data protection and privacy, and has actually pushed them to, at least in bills, although certainly in the Quebec law, the new Quebec law, impose some much more significant and privacy protective measures. So public involvement is a long way of saying that public engagement and public involvement can be really important in communicating to government that people do care and they do want to see action, because otherwise the voice that government is going to hear is an industry voice that says, go lightly, step lightly, back off, don't stifle innovation. And I think there has to be some counter to that voice. The other thing is, I mean, I've been very frustrated about the slow movement on privacy, and I'm also frustrated about slow movement on AI regulation and governance. I tried to remind myself that we're 2 years into a pandemic, which has been eating up a lot of government attention and government energy, just as it has had impacts on all of us. And so, you know, it's hard to say how much of a factor it has been simply that governments have had to direct energies and resources elsewhere and not on these things. You know, I don't want to make excuses for them, but I think that this may have been a factor in how slowly things have been moving. Unfortunately, at the same time, the pace of innovation, the use of data and the use of AI technologies has not slowed down at all. And so, you know, in the end, it may just put us further behind. But I think that's tremendously important. And then the other factor in Canada is, you know, is the impact of the federal system on, and I don't want to knock federalism because federalism has important values and plays an important role otherwise, but the inability perhaps to cooperate and to move forward in a harmonized way on certain key issues, to be able to move quickly and rapidly and in a harmonized way on things like digital issues, is very disappointing in Canada, and I think very problematic. And so in the end, it leaves you with, you know, either partial measures at the federal level because they are limited to, you know, what's within their jurisdiction, and then very uneven measures at the provincial level because of different provincial priorities. And it's very disappointing.
Who do you see as the leader in terms of the provinces from your research and perspective? It's been interesting to me to see what's been going on in Ontario. There's a lot of work that's being done in Ontario right now around, so the government has been working on a number of different projects, I think, that are relevant and related. One is a responsible AI, principles for responsible AI in government that they've been working on, and they've published both an alpha and more recently a beta version, and they've been consulting on that. They've been doing a lot of very interesting work on a health data platform, the Ontario Health Data Platform, which was initially created to allow for rapid response to COVID-19, and now the government is looking at a life for the platform beyond COVID-19, and it's intended to be a framework for sharing health data in a responsible and accountable way in order to foster important health innovations of benefit to Ontarians. And so it's an ambitious project and a complex one, but they've been doing a lot of work on that as well. And there have been some other things that, and the government had been consulting about a private sector data protection law. We now are less than or about 8 months away from a provincial election, and I think a lot of this is going to start to kind of, you know, stall pending the election. But Ontario has been doing a lot of work in this area, which I think has been interesting. Thank you.
Yeah, thank you both. And I was going to mention this later, but Donna gave me such a lovely segue that I'll mention it now. For folks that are interested in kind of the nuts and bolts around what next steps could look like around sort of legal and regulatory frameworks around AI, our hope for tomorrow is that we will have the chance for people who are interested in looking at sort of practical things that might be done or getting connected to organizations and groups that are already working on sort of how to move ideas into action. We hope that you'll join us tomorrow for digging into that conversation a little bit more. So just a little plug for what tomorrow is about, because it's a bit of an experiment. It's a little different than today. Thank you again, Donna. And I see Katrina also up on the white carpet.
Yes, thanks so much, Hero, and thanks so much, Teresa, for that excellent talk. I share all the same concerns and questions that Donna just raised, and those were kind of initially what drove me here, but maybe just to ask a more pointed question about that Ewert case. So I did read an article that you wrote about it, and what I thought was interesting, and I'd be interested to hear your thoughts on this. My sense of that, it was a data quality issue that really kind of won the day in terms of that case. And I just wonder if there's something there that could be pushed on further to kind of get the attention of organizations, companies, regulators, and so forth, using data quality perhaps as a wedge into some of these bigger issues. I'd be interested to hear your thoughts on that.
Yeah, thank you for that question. And that certainly was a yeah, and I think you're right. It was a data quality issue in part because the court hung the remedy on the interpretation of a particular provision in the statute that essentially required the personal data that's used to make decisions about an individual to be as complete, accurate, complete, and up to date as possible. And they found that there was sufficient that the studies from the United States that were critical of these surveys raised sufficient concerns about the accuracy and completeness that there was a failure on the part of Correctional Services of Canada to have made the necessary inquiries and to have, essentially ensured that the data was as accurate and complete. And I think it was a very generous interpretation of the statutory provision to provide a remedy in this particular case. Which is fine. Always good to have generous interpretations of statutory provisions. But there's so many things to unpack there. The Federal Privacy Act contains a similar requirement, which I thought was very interesting because the Federal Privacy Act has much broader application than the Correctional Services Act in terms of all the government personal information, federal government personal information. So if you adopted the same approach to that provision in the Federal Privacy Act, then it might actually provide some sort of support or leverage for bringing arguments that there was that AI systems used in government were not fit for purpose or not because the data was not as accurate. It was being used to make decisions about individuals, but it was not as accurate or complete or as up to date as possible. So that it might actually create traction in this other statute that had a similarly worded provision, which I thought was interesting. The problem, though, of course, is that is the ability to prove, and I think this goes to the problem with ex post facto approaches and the problems with putting the burden on individuals to do this kind of thing, is that for Mr. Ewert, there was the advantage of the fact that these tests that he was subject to had been around for a long time. They had also been used in another much bigger jurisdiction, the United States, where there was a lot of research and commentary on the tests and criticisms of the tests for around racial bias. And so there was a lot that he could point to say, everybody, it's pretty clear that there's a problem with these tests. And my concern is that it's that evidentiary burden that's going to be very challenging. And if you're in another context where a similar AI solution or test or something is not also being used in the United States, where are you going to get, or perhaps it hasn't been looked at yet by researchers, or it's relatively novel, where are you going to get that data that you can point to without having to create it yourself? And if you have to create it yourself, how are you going to get access to the data that's being used? How are you going to bring your own analytics to that data? And where are you going to get the resources to pay for that? assuming you can get access in order to convince the court. And so those are my concerns with this, and they're overall my concerns with ex post facto approaches, because it puts this tremendous burden on individuals. With respect to that, there's another case that I found very interesting from New Brunswick, relating to tobacco litigation. And again, so I've been finding my little AI cases, which aren't AI cases, all over the place. But this one, I think it's from 2019, from New Brunswick. Most provinces in Canada have passed legislation that allow them to go after the tobacco companies to recover healthcare costs related to tobacco-related illnesses. And that litigation has been proceeding through the courts in the different provinces. And in New Brunswick, one and a common issue is, how do you determine what the cost of the healthcare system was? And the province, of course, has access to all the provincial healthcare data, as well as other confidential data, and has hired its own experts to produce its reports on what its costs were. And in the New Brunswick case, you had the tobacco companies pushing back and saying, great, you did some nice analytics there, but we want access to the exact same data so that we can hire our own experts to do our own analytics, to see if we come up with different results. And so there's this big battle over, do they get access to that data? And the New Brunswick court decision was interesting because there were also privacy issues that were raised. This is private personal health information and so on. And the New Brunswick court was interesting because they basically said, yes, the tobacco companies should be given access to the data for the purposes of preparing their own analytics. And so to me, it's a really interesting case about transparency and access to data. It's an interesting case about privacy in that context, and how do courts guarantee privacy when they provide that access to data. And then it's underneath all of that, it's an interesting case about resources, because who but big tobacco has the resources to fight these battles in court to get access to the data and then bring their own experts in to produce their own independent analytics. And so it's a long-winded answer to your question. I'm sorry about that, but I see all of these pieces fitting together, and so there are bright spots in UART, but for me the cautions and the concerns are still very much there, and they a lot of them relate to just the capacity and the resources for ordinary litigants to be able to do this kind of work.
Yeah, that's wonderful. Thank you so much for that.
Thank you.
Yeah, thanks for that question, Teresa. Or sorry, Katrina, you're in different spots on my screen. That's a digital facilitation brain fart. So this sort of speaks, you've mentioned a few times the sort of difference between sort of the before and after approaches to regulating AI. And you had mentioned medical devices already get regulation. Like, you can't just put one on the market and say, oh, it's innovation and see what happens. You have to go through very specific procedures before bringing a medical device to market. And I was curious, so thinking about Clearview AI, obviously we don't have the same kind of regulation for tools used by the police. There doesn't seem to be an equivalent vetting process before the police use those tools. Do you see sort of those by industry or by use case kind of regulations as part of the answer? Or does it really seem like it's more, look, this is about big data and the risks that it involves for all of those different case studies that you had on your slide. And so we should be focusing at it in terms of regulating like AI and big data. Like, let's point the regulation at that issue as opposed to in health, in, justice sort of.
Yeah, I think sector-specific regulation is going to be important, and it's one way to have a really precisely focused assessment or evaluation that's tailored to the needs of that context. And so with medical device regulation, I mean, that's important to ensure health and safety. We have drug regulation and so on. The challenges in the health area are that it's not all AI will be characterized as a medical device. And if it doesn't fall within the definition of medical device, and it's not a drug, then is there a regulatory system for it? So this is one of the challenges right now in the health context is how to think about, we already accept that we're going to regulate the medications that people put into their bodies, the devices that are used in the healthcare context, that we regulate them. We have this system to govern them and to ensure they're safe and effective. But what do we do about AI, and how does that fit within those regulatory regimes, and what changes need to be made to bring it into those regulatory regimes? Once that's done, there may also be the need to change how they're regulated. And so, to give an example, maybe you have a medical device, and the medical device is approved, gets the stamp of approval, it goes into the market. It may be then that's it. The medical device is used and everybody lives happily ever after. But it may be that there are problems with the medical device that surface over time and that lead to injury or harms, and there are complaints or reports filed, and then perhaps there's an investigation or follow-up based on those reports. The problem with AI is that and it's one of its characteristics, especially with machine learning algorithms, is that it's constantly learning and adapting and evolving. So you may, if you assess an AI and determine that it's safe, effective, and that you don't detect any improper bias, and then you put it out into the wild, it may be that it starts to do things that nobody anticipated over time, and it starts to, or maybe that you're going to start to have problems. And so one of the questions with AI in the health context is, how do you adapt a regulatory system to something that doesn't remain the same or constant, so that you're only looking for unusual events, adverse effects that get reported, and then you respond to them, but that you've got something that's just shifting and changing, and your assessment of it in 2022 would be very different in 2024. But if you're not doing an assessment in 2024, you won't know. And so there's a lot of discussion of, how do you do this ongoing? Does AI require ongoing reviews over the life cycle of the AI to ensure that it is still on track? And how do you do that? And some have suggested, well, you use AI to do that. That would be a great way to process and analyze that data, is using AI. But the regulatory, the requirement for sector-specific regulation is there, but what sector-specific regulation will look like may have to change when it comes to AI, and that's one of the challenges. And Health Canada is looking at things like regulatory sandboxes for AI. I mean, this is something that Health Canada is working on right now, and trying to turn its attention to. The FDA in the United States is doing the same thing, and it raises some really challenging issues. So, if it's a sector where we've already determined that we need specific regulation, that'll continue, but it may have to end up looking very different with AI.
Great. Thank you. And that actually, it gives me another tiny plug. We have Len Polsky here from the Law Society of Alberta, who will be talking this afternoon about the sort of sandbox around regulations related to the legal profession, which is another one of those sector areas that AI ends up potentially affecting, or we need to sort of think about how that works. So stay tuned for Len's chat if that's an area of interest to folks in the audience. And also, if you really want to dig in, tomorrow will be a chance to sort of chat with Len one-on-one about what might this specific piece look like, or how do we sort of think about kind of the practical next steps around that. So thank you for that. That's one of the things that sort of came to mind as you were talking is I had these questions about, well, how do we harmonize quickly? Sort of, you talked about the big complexity of it, but then also that we need to move really quickly around AI regulation because it's evolving so fast. And then you answered, I thought, your own question by saying, well, just get on with it. We just have to do it. It has to happen. But I'm curious in terms of that play between like individual sectors, or we sort of already have like, Treasury Board at the federal level working on that for its domain, or you have sort of Health Canada looking at it for its domain. But in some ways, it seems to me there's this kind of like, everyone is affected by AI and everyone's sort of responsible for parts of it. So it ends up that no one's kind of responsible, and it's not always clear, like, sort of where to go from there, or who sort of picks up that flag and says, we're working on it. Treasury is maybe an example of that.
Yeah, I think a good example of that is the Toronto Police Services Board consultation on use of AI by police services. I think that really is an example of a police service saying, well, if government's not going to help us with this issue, then we'll do it. So yeah.
Do you see a use for sort of tables or more concentrated discussion on sort of regulating AI specifically, and kind of having that, I know, for example, the environmental movements kind of run into the same issue. Like, well, there's so many things that affect the environment that we kind of need to think about that issue, and then how all the different pieces of regulation might affect it. Do you see kind of a similar movement around AI regulation kind of springing up, or a need for that, or?
Yeah, that's an interesting question. I do think that I do think that there is room for a systematic study. I don't know if it's on a province by province basis, or or at the federal level, like a systematic study of the laws and the legislative framework of a jurisdiction, say Alberta or Ontario, and to analyze it from the perspective of what needs to be done to bring everything up to date. I mean, this is a big project, right? To bring things up to date to address the challenges of artificial intelligence, because it may mean, I suspect it's over time, it's going to mean that we need amendments and changes, some of them small, some of them, procedural, but we'll need things to address AI in a whole range of areas. And in some areas, it's going to be much more complex than others. But it might be nice to have that overall survey picture done. Who's going to do it? How long it'll take, and who's going to pay attention to it, because we've seen so many times in the past these really wonderful pieces done, and then nothing happens to it. I don't know, so and that makes it sound like maybe it's not such a thing worth doing. But I know the Law Commission of Ontario has been working on public sector AI, and we'll have a report coming out in the next few months on public sector AI, which I think is really interesting. But one of the challenges that they've run up against is just the vastness of it, and just how broadly it reaches. But it's, again, an attempt to do this kind of assessment of the context and of what is needed in the context. And I think that that's valuable. Maybe instead of province-wide, it is sector by sector, as you suggest, maybe, looking at the environment and doing an overall assessment of what's required. I don't know.
Thank you. And I know that question sort of asks you to look into a bit of a crystal ball. So thank you for speculating on what that could look like. I just want to acknowledge we're kind of coming to the end of our time. I don't know, Donna, if you wanted to comment on your comment, or if you had a question about that, or if your comment speaks for itself. So if you want to come on up, that's open to you. I guess it kind of
speaks for itself.
Okay, good. Just wanted to make sure that it did. So thanks for adding that. The other thing I guess I wanted to touch on a little bit, or ask you to touch on rather, is, you sort of mentioned a number of times this thread around power imbalances, like looking at sort of the case of the Métis man who did win his case, but it was a significant effort, or looking at big tobacco companies that have the resources to do things that individuals might not, or one of the cases that strikes me that's not quite on point for AI but is related, I think, is the Facebook case, where there was a woman who was surprised her kid's picture was being used in Facebook advertisements, and what it looks like for that one person to sort of stand against Facebook and say, I don't think that's fine. So do you have any comment on kind of the power imbalances that are introduced by AI and how that fits into the regulation?
Yeah, and I think that is tremendously, the power imbalances are tremendously important. One of the Virginia Eubanks, in her very interesting book called Automated Inequality, looks at automated decision making in the U.S. context predominantly, and in government. And part of her argument is that governments introduce automated decision making systems for the most part with respect to the least advantaged members of the community. That you're, the first place that you're going to see AI introduced is going to be around access to public housing or social insurance benefits and so on, and that this is a pattern, and you see them, and part of that may be that these are high demand contexts in which some people feel that there's a real potential for AI to help with the workload and to administer things more fairly, whatever the rationale might be. These are the areas where you often see automated decision making being introduced, and when that happens, then you have an experiment with automated decision making in a context where you have people who, if you're struggling to keep a roof over your head, you probably don't have a lot of financial resources, but also a lot of emotional resources and free time to be pursuing litigation with respect to unfair decision making in that context. And so I do think that the power imbalances are really important, especially given how some of these tools may be distributed and who they may impact more than others, the ability to respond to it, and also the complexity in responding to it. So I think that the just keeping in mind the power imbalances is tremendously important. The other thing is, of course, this is a little bit of a digression. I'm just going to mention it. I've been following class action lawsuits for data breaches fairly closely for a while now. And it's really interesting to see some of the trends and patterns in that context. I think class action lawsuits for data breaches have multiplied in number, in part because people have been so frustrated that there hasn't been more that could be done about for data protection. So the laws have fallen out of date, the recourse is seen as ineffectual, the imbalance between companies like Facebook and ordinary citizens, is seen to be such a vast gulf, and it's not properly addressed under current data protection laws. So you start to see just the rise of these class action lawsuits, which at least come with significant financial consequences, whether they're successful or not, for companies, and they come with reputational consequences. And so it's a way of getting something done, which has been interesting. But and so that's been interesting. It's kind of a self-help using the publicly funded litigation system to try and get results that are not available from regulators. So lesson number one. Lesson number two, many of these suits are now running up against privacy laws, privacy torts, and statutory privacy torts that were not designed for this context. And so they're running up against problems with framing their claims or their causes of action, because the data protection problems don't map onto the privacy torts in an effective way. And I think this is what we're going to start to see more and more in this context. And that's a failure of the law to stay current and up to date with the reality of the data society. So that's another problem. So anyway, I'll stop there because I know I'm taking up a lot of time.
No, thank you. That's much appreciated. And I could ask you questions all through the lunch hour, but we should probably wrap it up. So I'll just say thank you so much for your generous presentation and letting us pepper you with so many different kinds of questions, and really opening up some of our thinking about this. I really appreciate it, and I suspect I can speak on behalf of our comfortably lounging audience that they appreciate it too. So thank you again for joining us, and I'm going to pop back to the main room and tell everyone a few things about what's coming next. So I won't say that here, but just thank you again to those who asked questions, and Teresa for your presentation. And I hope this is the beginning of more conversations.
Thank you so much. And thank you to everybody for attending.